Welcome. My name is Tom Leonard. I'm president of TPI, and welcome to our panel on Patent Reform 2.0. It's been barely 2 years since the first major patent reform legislation in years was enacted, and yet patent legislation is once again on the horizon. Notwithstanding the reforms that have been enacted, serious concerns remain about the patent system, particularly as it applies to software that is characterized by wasteful litigation that ultimately is harmful to innovation. Major complaints involve patent assertion entities, less charitably known as patent trolls. And in response, the Federal Trade Commission has held workshops and issued reports. The White House has proposed a number of administrative and legislative fixes, and Congress is poised to act with a number of bills pending. The measures under consideration include, not necessarily in any particular order, tightening restrictions on functional claiming, greater specificity on patents and claims infringed, greater transparency on patent ownership, expanding the covered business method review program, fee shifting and limiting and/or shifting the costs of discovery. The common theme is to try to correct an imbalance in the costs of patent litigation that proponents of reform believe is responsible for current problems. Despite the flurry of legislative activity, a lot is still unknown about PAEs and, as well as the proposed reforms, as indicated in a recent speech by FTC Chairwoman Ramirez. While she acknowledged the adverse impact of PAEs, the Chairwoman stated that, quote, the analysis of the costs and benefits of PAE activities remains limited, and the FTC has just authorized a more comprehensive study. Well, we have a very distinguished panel to discuss these things today, and I've asked the panel to address the following questions related to PAE activity and to the pending reform measures. First, how much do we know about the benefits and costs of PAE activities? Are PAEs a problem, or are they a symptom of problems with the patent system itself, particularly as it applies to software? And are the remedial measures currently under consideration likely to yield net improvements? I have asked the panelists to talk for up to 10 minutes. Corey, sitting over there, will police that, and will hold up signs telling them where they are as far as the 10 minutes are concerned. We're going to go, the order we're going to go in is actually just determined by the panelists. We're going to start with Michael Moore, go to Matt Levy, then to Peter Detkin, and then to John Duffy. So Michael is both a lawyer and an economist. He's a professor of law at Boston University, where he's taught courses in patents, intellectual property, and public policy towards the high-tech industry. Among his many other activities, he's served as an expert witness for the FTC on a merger case, presenting issues related to patent licensing. And it's a pleasure to have Michael here. Michael.
Thanks very much, Tom. I learned a lesson, I guess, being an outsider from Washington, I should have been more attentive to, but I showed up late, and so I was selected to go first on the panel this morning. I think that's fine. Tom suggested that we address 3 questions, and I'll read the first question to you, and I'll just directly answer. It says, are PAEs the problem, or are they a symptom of problems with the patent system itself, particularly as applied to software? And my answer is going to be yes, yes, and yes. So that I do see a special problem with PAE activity, but my concern mostly is about systemic problems that I believe arose, excuse me, I have a cold coming to deal with. Systemic problems of the patent system, and I think that arose over time, but mostly in the 1990s. And I think that the problems with our patent system were evident for an entire decade of the 90s before there was significant activity by PAEs.
Scholars and policy analysts have looked for a culprit here, and there are three candidates that might explain why the patent system is not performing very effectively. One is that it is too easy to get a patent. The obviousness standard, for example, might be too easy to satisfy. Number two, given the standards that are in place, mistakes are made, typically at the patent office, so that patents are granted that should not be granted. Those are both versions of what people generally speak of as patent quality problems. I, along with my frequent co-author Jim Besson, have pushed very hard for people to focus on a third kind of problem. If you want to, we could call this another kind of quality problem. It's the problem that we call notice failure. As we look over the history of the last 30 years of the US patent system, we think that the evidence best supports the perspective that says that it's because of deterioration of notice that our patent system is performing poorly. When I say notice, I hope many of you recognize the term. What I mean is that our patent system is not always performing very much like an idealized property system. An idealized property system would provide information to technology developers about the existence and scope and ownership of a property right. So that in the case of land, before you develop a project, you find out what the boundaries of your parcel might be. You find out the boundary of neighboring parcels. You either avoid infringing the neighbor's property rights, or you purchase the rights you need in advance. Those two kinds of activities are critical to a well-functioning property system. We think that mostly in the 90s, but over the span of the entire last 30 years, we've seen a deterioration of notice in the patent system. You see in particular that the costs of defending against patent litigation to firms who are outside of the chemical, medical, or pharmaceutical industries exceeds the benefits that they derive from the patent system. We believe that most of those costs are borne by defendants who inadvertently infringe. Therefore, the patent system is imposing a tax on the activity that makes you liable as a defendant. What is that activity? It's innovation. The decision to innovate makes you liable against someone else's patent, in a patent suit asserted by someone else, in a world in which it's very difficult to avoid that infringement through ex-ante licensing or through ex-ante design choices. The empirical work that Besson and I have done shows that starting in the early 90s, continuing through to today, the net costs of patents exceed the net benefits for publicly traded American firms outside of chem and pharma. In contrast, in chem and pharma, over that entire time period, the patent system is providing the subsidy that it should provide. That's because chemicals are typically claimed structurally. You claim a chemical by what it is, and so that strangers can look at those claims and understand them and do the two things I described before: avoid infringement or negotiate in advance for permission to use the patent-based property right. Not just in software, but especially in software, you see much more functional claiming. And I don't mean simply here 112 paragraph 6, or now paragraph F. I'm talking about language that might seem structural, but really allows for great scope, great ambiguity, great vagueness. So those are the sorts of problems, I think, that have created an explosion of patent litigation, making our patent system not perform well outside of chemicals. Now, when you take a look specifically at patent assertion entities, you see that, as I said, they were not really in evidence over the period of the 90s. For the last decade, they grew from being responsible for about 5% of patent litigation in the year 2002 to over 50% of patent litigation today. So something dramatic has happened. What I think has happened is that the problems with the patent system are better exploited by non-practicing entities than by the operating companies that have been exploiting the deficiencies in the past. So the problem persists. It's been aggravated by assertions by parties that have greater bargaining power. So the tax that was already present is being magnified. The second question that Tom asks us is, how much do we know about the costs and benefits of PAE activities? Well, I gave you that long background because I want to stress that what I think we do know is that the patent system as a whole, whether PAEs are important or not, it's a patent system that's not performing what it should, which is provide a subsidy to innovative activity outside of chem and pharma. Second thing that we know is that there has been an explosion of litigation over the last 30 years. It's outstripping the pace of investment in R&D by a considerable factor. We know that there's been a dramatic increase in the amount of litigation by PAEs, so the identity of the parties asserting the patents has changed. I don't think anyone can dispute any of those points. What do we know about the costs of PAE activity? That's controversial. So Besson and I, with the assistance of RPX, did a survey where we found that there was about $29 billion a year in costs associated with NPE assertions. Besson and I did an earlier study with the assistance of Patent Freedom that generated a larger figure, $83 billion per year. The larger figure is a different methodology. The second study was based on a survey. The first study was based on what's called an event study. We looked to stock market reaction to the filing of NPE lawsuits to calculate what the costs of those suits might be. Both of those measures are rough, but they're comparable in magnitude. The second study is significantly larger because it includes indirect costs. So the third thing I want to tell you is that there's a study by Catherine Tucker at MIT who helps us unpack a little bit of the story behind the indirect costs. She looks at a campaign by Acacia against companies in medical software. And she finds that the companies that were sued by Acacia saw a 1/3 sales decline relative to companies not sued, which she attributes to 2 years of lack of incremental product development, as managers in those companies were told to hold off on innovation until these lawsuits were cleared up. So Tucker is helping us understand one kind of indirect cost. My intuition and the research that I've seen done so far suggests that indirect costs of patent litigation, whether it's asserted by an NPE or by an operating company, might be quite a bit larger than the direct costs in terms of settlement payments, damages, and attorney's fees. So don't lose track of very large costs associated with litigation that are not being measured by anyone except people that use something like the event study that we've done. On the benefit side, it's very difficult to see what the benefits of NPE activity might be. Besson and I took a peek at some data. We looked at 14 publicly traded NPEs, and we tried to see how much revenue they generated to try to put an upper bound of what they might have transferred to inventors or devoted to their internal R&D. We find that the number was about 26% of the cost that was being imposed on defendants. We think that there's fairly little evidence that any kind of significant financial benefit is being delivered to independent inventors, and we think, in fact, independent inventors or small high-tech firms are more likely to face a problem because of NPE activity, or more generally, a problem because of notice failure in the patent system. The harm that they face, like the publicly traded firms face, from assertions against them, I think is bigger than the benefits that they could be deriving from patents. Thanks very much.
Our next speaker is Matt Levy, who is a patent counsel for the Computer and Communications Industry Association, CCIA. He has also been an attorney at Hogan and Hartson, Finnegan Henderson, Faribault, Garrett, and Dunner, and most recently at the boutique firm of Clatterjee Law, PLLC. He has firsthand experience in patent litigation, representing a number of large companies. He's also filed and prosecuted patents before the U.S. Patent and Trademark Office. He is a co-inventor on a U.S. patent application, and pleased to have him here. Matt?
Thank you, Tom. That's actually an issued patent now. It took 10 years, but that's all right. First, I want to thank Tom for inviting me. This is an illustrious panel to be a part of. I'm honestly not sure exactly why I'm here, but I'll do my best. So my approach here is, sorry about that, let me pull back. My approach is actually not to deal with all three questions, but I want to focus actually on what comes after what Mike was talking about. So Mike was talking about patent quality, and what I want to talk about now, go ahead, is really what happens when we have the bad patent out there. How do we challenge it? And we're going to get into a lot of other details, but there's a lot of reform proposals going on the Hill. Chairman Goodlatte in the House Judiciary Committee introduced a major bill this week, so that's going to be on a lot of people's minds. So how do we challenge a patent? First, to prove the patent's invalid, there are a number of grounds you can use. You can show that it's in the prior art. You can show that the claims aren't clear, they're indefinite, that the patent doesn't teach how to actually implement the claims. These are not all the grounds, but these are some of the major ones. Go ahead. There are two basic places you can challenge a patent. You can challenge it in court, you can challenge it at the PTO. So challenging in court. Now, the problem here, go ahead, it's very expensive. And part of the problem is really the standard of proof. So when we consider the problem of, are PAEs the problem? My answer actually is no. I think they're a symptom of a fundamental problem in the patent system, really a misweighting of the burdens. So here's the standard of proof this is just equally balanced. Go ahead. So in a normal civil case, you have to prove things by a preponderance of the evidence. You can see just more likely than not, just a little bit more likely. In a criminal case, it's beyond a reasonable doubt, which is a very high standard of proof. And the problem here, go ahead, in a patent case, we use a different standard. Go ahead and click. So to show that a patent is invalid, you have to prove facts by clear and convincing evidence. And as you can see, that's a much higher standard than just more likely than not. And it's very difficult to reach that burden. So once a patent issues, it's not completely safe, but you're going to have a hard time proving it in court that the patent is invalid. You've already got the deck stacked against you, even if it's not a great patent. So what are your options? The other option is to challenge at the PTO, which is certainly much cheaper. There are a few programs that were created by the America Invents Act that people can use. There's post-grant review, something called inter partes review, and the covered business method patent review. Now, the most commonly used one that applies to any patent, after it's been around for at least 9 months, you can use inter partes review, so you can challenge any patent or ask the PTO to review it. Go ahead. The problem with inter partes review is that it's very limited. So these are the possible grounds that I put up before. Go ahead and, but all those things are just crossed out and you can't use. You can only challenge it on prior art grounds. And in fact, among the types of prior art you might use, go ahead and click, you can't use them all. You can only use a couple of types, publications or old patents or patent applications. So you're really very restricted in how you can invalidate a patent using inter partes review. Now it applies to everything, or anything is eligible, but you have to come up with prior art. So even if the claims are indefinite, even if they're not, even if the patent doesn't teach you how to do it, or more commonly in the patents that we're talking about, these software patents, even if the patent is abstract and really shouldn't be eligible to be patented, you cannot challenge that through inter partes review. Go ahead. Now there is a program that would let you do that. That's post-grant review. You can challenge it on any grounds, but as you can see, go ahead and click. It's only available during the first 9 months of the patent's life. Now, I think it was Jim Benson who just came out, the average age of a patent that's used by a PAE is around there. It's about 12 years old. So PAE patents are probably not going to be eligible for post-grant review. So that program doesn't help. So right now we've got the courts. It's a really difficult and expensive process to show they're invalid. The PTO is cheaper, but you're really limited in what you can do. So there's one program that's left, which was also created by the American Defense Act. It's been around since September of last year. And this does let you challenge on any grounds. The review is by administrative judges, not patent examiners, which, as we'll see, is important. What I want to do is just walk you through how the PTO actually screens these things. So when you want the PTO to do this covered business method review, there's a whole set of tests that we have to get past. So first, have you actually been the target of an assertion? Did somebody sue you or basically threaten you with the patent? If not, that patent is not eligible for CBM review at all, so you can't use the program. If yes, then we look to see if it's for a financial product or service. When the program was created, it was created for a limited set of business method patents, namely that were troubling the financial sector. So that when the PTO actually looks at, the PTAB looks at petition to see if they're going to accept review, they'll see, they apply this test. And we'll talk a little bit about what that means later. If no, they just deny the petition, you're done. You get back some of your fees and that's it. If it is financial, then they ask, is it for technological invention? Part of the CBM program is that it does not apply to technological patents. If it is a technological patent, again, deny review, you're done. If it's not, then we go on. And finally, this is all before they even accept review. The PTAB decides, has the petitioner proven that it's more likely than not that the patent's invalid? If not, they deny the petition. If so, they grant it. So we've got all these different screens just to get to the point where they even review the patent at all. So for patents that are fairly solid, you can see that they're probably not going to get reviewed. Now, in the first year, we have a little bit of data. I know that Senator Schumer's office is compiling some other more interesting stuff. Hopefully we'll have that next week. There were 54 petitions filed in the first year, 12 granted, 3 denied. So this is already, although it's a small sample set, the denial rate actually is higher than it used to be for ex parte re-examinations, which were the old way, the old primary way to challenge patents. There's only been one final decision, but again, it does take some time. That one came out, I think, 9 months after filing. So I think that's it. Go ahead. Oh, right. So you can see that the CBM program is being used, not that heavily. It's only 50 or so petitions, but so because this allows you to request review on so many different grounds, there have been a couple of proposals to expand it. One is which is in Chairman Goodlatt's bill, is to expand the definition of what a financial product or service is. I will say that if you read the bill, it's a little bit opaque as to how this works. So I'm going to give you my explanation of it. It says that this term, or the whole term, which is a little longer than this, should be interpreted according to a case that came out of the PTAB. It's the SAP v. Versada decision. That case involved a patent that was for something that the patent owner called hierarchical pricing. The basic idea is you go to a vendor to buy something and you may be entitled to any number of discounts. For example, maybe there's a discount for your region, or maybe there's a discount for the size of your business, or maybe there's a discount on printers that week. So the invention is to go through all the possible discounts that you're entitled to and give you the biggest one. So this is just pricing. The PTAB said that was a financial product or service. That's a fairly broad interpretation, so the Goodlatt proposal would enshrine that. The other proposal, which was made first by Senator Schumer in the Senate and then Representatives Issa and Chu in the House, is to basically expand it to cover essentially all business method patents. So these are the two proposals that are out there, and we'll talk, I'm sure, a bit more about the possible consequences, whether this is a good or bad thing, and our organization is supporting the expansion of CBM. I think that's pretty much it. So the basic idea here is that PAEs are a symptom of the problem. As we're going to see, though, because of what Mike said, that there's a lot of cost here. If you have a 105-degree fever, there may be an underlying cause, but you still treat the fever. So we do still need to deal with the problem. So let me wrap up there, and I'm looking forward to questions and the discussion as it goes forward.
Thank you, Matt. Our next speaker is Peter Detkin, who is founder and vice chairman of at Intellectual Ventures, which is kind of the granddaddy of PAEs. Prior to
make me feel old.
What? Prior to joining or founding Intellectual Ventures, he spent 8 years at Intel, where he was the vice president and assistant general counsel, responsible for managing Intel's patent and licensing departments. Prior to that, he was an intellectual property partner at Wilson Sonsini, and it is a pleasure to have him here as part of this panel. Peter?
Thank you, Tom. Appreciate the opportunity to address this crowd. I'm going to start just briefly with an overview of Intellectual Ventures, because there's a lot of misconceptions about who we are and what we do. What we do at the end of the day is we invest in invention. We do that 3 ways. We buy, build, and partner. We build. We have our own lab in Seattle. We have over 100 scientists there. We invite really smart people in there to invent really cool stuff and solve problems, which we then monetize. We monetize several ways. Either we do spin-outs, we have a couple of spin-outs, we'll license, we'll sell, we'll do what makes sense under the circumstance with the intellectual property that we generate in our labs. We partner with research institutions around the world, which is really an extended model of our own lab. Namely, there are people who have expertise around the world that we simply don't have and can't replicate in our lab. As an example, Korea leads the world in wireless technology. We partner with the Korean Institute of Science and Technology. We're on their campus. Our office is on their campus. In wireless technologies, we work with them to try to solve problems. We help secure the rights to the inventions that come out of that. We license that out and we share the revenues with the inventors. We do that with universities and research institutions around the world. And finally, we buy. We buy other people's inventions. This is probably what we are most known for. Some might say notorious. But at the end of the day, all we're trying to do is create a secondary market for inventors. We're trying to help reward people who are out there inventing and help them get the rewards that they're entitled to for their inventions. On the other side, we then take those inventions and we license them to companies, or we'll sell them. We'll, again, do whatever makes sense under the circumstance. But all we're trying to do is connect people who are creating invention with people who are using invention. Anybody in Silicon Valley or elsewhere, any tech company will tell you that most companies use far more inventions than they have created in-house. There's no tech company that has created every invention in-house that they're using in their products. And they need access to the inventions out there. They need an efficient way to get that. We think that we provide that efficient method. I can talk a lot more about that, but I have limited time, so let me turn to the questions. What do we know about benefits and costs? The answer is not much. Look, I'm not an economist, and I don't pretend to be. I'll leave that for others. But some data quickly from government reports. There are 40 million jobs that are attributable to IP-intensive industries. IP-intensive industries can constitute more than $5 trillion, contribute more than $5 trillion to the U.S. economy. When it comes to the software field, there is no question that all the latest figures show that investment in software continues to rise. Most recent quarter, it's as high as higher than it's ever been. One quick data point, and this is public information. We pumped several $billions into the invention economy. This is money that we have paid to inventors. Michael Moyer referred to, said there's not much data out there. Here's some data for you. More than $500 million paid to independent inventors. Over $700 million paid to small companies. Not a lot of other good data out there, I'll tell you that. Michael Moyer referred to 60% figure of litigation that was brought by small companies. GAO figures differ. GAO will tell you that when you adjust for a recent court in the law from the AIA. The number's actually about 20%. Numbers this different would suggest that there's not really good data out there. The $29 billion number I've seen, that calls everything cost. I've got news for folks. There's actual infringement out there. Not every litigation is frivolous. Yes, there are some frivolous litigation. I'll get to that in a second. No doubt. Yes, we need reform. There are reports I saw in yesterday's newspaper. We're against reform. So any reporters in the audience, please report. We are not against reform. There are problems out there. But the $29 billion figure, that includes, for example, one publicized case, where the plaintiff not only won, the district court found valid and willfully infringed. That was affirmed on appeal. That was counted as a cost. I think that's, again, I'm not an economist, but I understand that's more considered a transfer. You can't treat all infringement suits the same as abusive suits. And by the way, while I'm looking for data, why don't you look for data on the cost of infringement? I haven't seen anything about that. Okay, are PAEs the problem? Patent holders. Why do we have to characterize people? I've seen PAEs, trolls, NPEs, PMEs. Rather than coming up with new acronyms, let's focus on the problem. Patent holders are patent holders. Some are good, some aren't so good. But the question is, let's look for abuses of the system and look to correct that. Now, Matt just gave you a very good exposition of what the AIA laid out. It was a very comprehensive reform bill. It took 10 years to pass, and it's been in existence for a little under 2 years now. When it comes to improving the patent system, I think that we have to give that a chance to work. You saw some data there from Matt. I believe that's the accurate data. I have no argument with that data. John may think differently, I don't know. But let's give that a chance to work. When it comes to pure patent, there's some tweaks that can be made. I understand that, and I think Matt's points on that issue on tweaks to the AIA are well taken. But either way, when it comes to patent reform, let's give the AIA a chance to really work. But instead, what I think we should be focusing on, and what we are focusing on, and what Representative Goodlatt's most recent draft focuses on, is litigation reform. That's where some work can still be done. And that's what the proposal is. That there are a lot of proposals out there, and that's I think they all focus on things like things that are in the nature of litigation reform. Because what the real problem is not the nature of the patent or the holder of the patent, it's how it's being used. The phrase troll originally comes from companies, believe me, I know, I actually coined the term, that were taking patents that are poorly drafted, provide no notice, is what I was referring to, or poor notice, or are invalid, asserting them broadly across the industry, looking for, frankly, nuisance value settlements. If you send out 1,000 letters and you're looking for something, $25,000 to $30,000 each, which is cheaper than it would cost to go to a lawyer and get a good analysis, you connect on a third to half of those, you got a good little business going. It's not particularly ethical business, but you got a good business going. That's the problem that needs to be solved. Or if you follow suit, clearly just looking for nuisance value settlement. So some of the litigation reform we've seen calls for fee shifting. Applied bilaterally, I have no problem with that. We're for that. When I say bilaterally, there is infringement out there, and there are defendants who will put forth frivolous defenses, will willfully infringe, and their fees should be shifted just as surely as should the plaintiff who asserts a frivolous patent. There are other aspects of patent reform that we think, and by the way, that is reflected, I believe, in Representative Goodlatt's proposal. That's not in some others, but that is something that we agree with. I could go through some of the other issues, but again, we think the reforms are generally fine, devil's in the details. But like any big, complicated system, there's room for improvement, but let's be careful and not create more problems than we're solving. Let's not, for example, with some of the heightened pleading standards, again, something we're for, something that's in Goodlatt's bill, but you go too far on that, now you're creating a lot of satellite litigation with motions to dismiss that can go on forever if you say that the complaint needs to include a million things. Should it include more than simply, I got a patent, you're infringing, haha, I'll tell you later what I mean? Yes, it should. And that's the current standard, by the way. No, that's not appropriate. Should it include more notice of, this is why I think you're infringing? Yes. Should the defenses, again, make this bilateral, should the defenses also say, here's why I don't think I'm infringing? I'm not just going to assert every invalidity defense in the book, 102, 103, 112. I'm going to tell you why. And let's not forget about misuse and the antitrust claims. You got to tell me why you think it's invalid. Let's make this bilateral. I'm going to end on that point, actually. The key at the end of the day is let's focus on the abuses of the system. Let's not focus on who's holding the patent and what their motivations may or may not be. A patent is a patent. A patent holder is a patent holder. That's where the focus should be on how those rights are used, how those invention rights are used. Thank you.
Thank you, Peter. And finally, we have John Duffy, who is a professor at the University of Virginia Law School, where he's been since 2011. Prior to that, he spent almost a decade on the faculty of GW Law School. He's head of their intellectual property program, teaching administrative law, patent law, and international intellectual property law. He has been identified as one of the 25 most influential people in the field of intellectual property in the U.S. by American Lawyer, and one of the 50 most influential people in the world by the UK publication Managing Intellectual Property. He has clerked for Judge Stephen Williams at the U.S. Court of Appeals and for Supreme Court Justice Antonin Scalia. He worked at the Justice Department in the Office of Legal Counsel and at Covington and Burling prior to going into academia. And again, it's a pleasure to have John with us. Thanks.
Thank you very much. I wanted to start out with a little bit of historical context, because I think what we are seeing is a revolution, and a revolution that we should be happy about. In the 19th century, one of the greatest fields of federal litigation and federal practice on economic matters was patent practice. In the 20th century, it became a sort of small niche market, and antitrust was the big market. And there's a reason for that. It's because in the 20th century, the economy was more dominated by large regulated industries. That's what I was taught when I was in law school. We studied regulated industries. I took no intellectual property classes when I was in law school. Regulated industries was the way to go. The entire phone system of the United States, something where we now see patent wars. The entire phone system of the United States throughout most of the 20th century was dominated by a centrally controlled, regulated monopoly. That's changing. That changed in the last quarter of the 20th, well, really last 15 years of the 20th century. And because of that, we now have a more atomistic entrepreneurial activity, atomistic and entrepreneurial activity. That changes the way we innovate. When AT&T was the phone company, the monopolist, they had a very large research lab, several of them in fact, I worked at one of them, that made all the innovations. Intellectual property is not so important. If you are the phone company, you have a monopoly, you don't really need an exclusive right to obtain, to practice the patent, because you already have exclusivity over the entire phone system. Now, I'm not sure that was a good system, but nonetheless, there was a lot of innovation, there was a lot of debate in the 20th century, a whole academic debate among economists about whether centralized innovation was superior to atomistic innovation. Whatever the answer to that debate is, we've left behind centralized innovation and massive monopolistic practices, at least in that one industry, which we now see a lot of patent litigation. We see patent litigation because we disaggregated innovation from the practicing entities. So when I worked at the AT&T Bell Labs, everything in this massive building, everything that was done in this massive building was non-practicing entity. Everybody in there was a researcher. We didn't build anything except ideas and information and technology. And then we supplied it to the monopolist telephone system. It was just that, it was right on the cusp of it breaking up. But nonetheless, we supplied it to the monopolist entity, which was somewhere else, and they practiced it in other entities. That system is broken up. So now the labs are independent of the practicing entities. We should look at that and say, there's something terribly wrong about that change. We should actually welcome that change. Indeed, today, in even popular culture, we say, what would people like to be? They'd like to be innovators, and they'd like to be startup innovators. Well, startup innovators, people who work in their garages, might be very good at creating ideas. Indeed, the lab I worked in only had 5 or 6 people in it, and that was it was its own lab. It was working on its own ideas. That kind of work can be done in a atomistic or done by small businesses. And the question is, what do they do with their ideas once they've completed them? They no longer are corporately integrated into a monopolist. One thing that they can do with them is they could try to build a business, and I think that's a good thing to do, but many innovators, many scientists, and I used to work with them, they may not be good at business. They may actually decide, we're not good at business, we're really good in the lab, we're really good at technology, but business is a mystery to us. We did not go to business school, we did not take economics. We want to sell our ideas. And what they will do then, instead of just simply sending it up the management chain, which is what they used to do in a large corporately integrated firm like AT&T, they will come to somebody who is a patent assertion entity, somebody who wants to buy their ideas and then license it to other people who are in the business and who can practice the idea. That change is a huge change. And we should not look at that and say it's a small thing, it's a minor thing, it's a problem with the patent system, or it's a symptom of the patent system. It is a symptom of an overarching change that has occurred in our economy. And you can have your own opinion, but my own view is that demonopolizing major industries and having more atomistic competition, having intense competition, is probably not a bad thing for our economy. It will lead to more litigation. There will be more uncertainty, there will be more litigation, but nonetheless, if you compare those costs to the costs of having a monopolist, you have to not pick the best of all possible worlds where there's no litigation and the world is run by angels. You have to choose between worlds that are conceivable and possible. So I would rather have the atomistic system where there's lots of entrepreneurs, there's lots of ideas, and there are middlemen. There are middlemen instead of managers integrated into a corporate structure. And the middlemen are going to be firms like Intellectual Ventures. Do you mind being called a middleman?
I've been called a lot worse.
Yeah, so I think that is what we're doing. So if you compare that, if you think about the patent assertion entities as simply supplanting the management of a large corporately integrated firm, you say, well, this is the way things get done. This is the connection between the laboratory and the practice. There always was that connection. It used to be corporately integrated into a large corporation. Now we're disaggregating things. It does mean that you can see this in a lot of different ways. You can also see it in the practice of law. Patent law used to be a rather small backwater, a niche. And antitrust in the 20th century was the big thing. Antitrust is no longer as much as patent law is. If you look at the people who are litigating patent law, they are the big, former solicitor generals and other people like that. It is where the money is today, and there's a reason for that, and the reason is not necessarily a negative reason. So that's the first point I want to make. I think it's a very broad point, but I think we should step back a little and think about where we are in the history of economic development. I'll say some kind words about patent assertion entities or patent trolls, and then a few maybe not kind words. So I think they do decrease the costs of asserting patents. Even Michael Moyer's papers on this say, well, if you read them carefully, you realize they must be doing that because the data show that they are asserting some more marginal patents. And the only way that they could assert those more marginal patents and still make a profit if they're rational is that they are able to have lower costs associated with asserting their patents. They increase liquidity in the patent market. We've already heard that, but it's important to realize what this is. As long as we say patents are property rights, and Congress has said that in a statute that's very old, as long as we say that patents are property rights, almost any economist, I think, and I don't think Michael Moyer would disagree with this, the property rights generally should be alienable. I mean, they should be saleable. That generally is, there's a large economic literature on that. There may be very rare exceptions to that, but generally speaking, property rights should be alienable. If you allow alienability, then you're going to have secondary markets. Just like if you allow alienability, like when I buy a new car, I can resell it after a few years. If my needs change, I can resell it at a secondary market like CarMax or something like that. And that's just something that is going to exist as long as we treat these things as normal property rights. The third benefit, I think, of patent assertion entities, which I think is actually overlooked, is that patent assertion entities have strong economic incentives, very strong economic incentives to value patents accurately. Now this is a little, if you think about this for a minute, it's intuitive. If you're in the business of asserting patents, you're going out there and buying patents. You buy a lot of patents. Intellectual Ventures buys a lot of patents. They are the used car salesman. They have to figure out which
Like I said, I've been told worse.
Okay, so I like used car salesmen, but nonetheless, they go out there and they have to value these patents. And there's a large academic literature on valuing patents, but the amount of resources that have been devoted by academics or can be devoted by academics is, you know, they might get a grant from an economic research institution of a few $100,000 to sort of collect data and try to figure out, gee, what are patents, you know, how do we value patents? That's nothing, that's peanuts compared to the resources that somebody who's got real money on the line, hundreds of millions of dollars on the line, will devote to the technology of evaluating patents. That's a huge social benefit. There's a collateral social benefit to this, which is that it provides us with better technologies, probably technologies to evaluate patents. Much of this is probably trade secret right now, but we all know trade secrets eventually leak out into the public. So there is a growing technology of how to value patents, and I think that's a benefit. The negatives that you can say about patent assertion entities.
I think you're out of time.
I am out of time? No, he didn't pick it up. The negatives about patent assertion entities, I think Peter already said, look, there are some entities that might try to basically game the system, and especially game the system of collective action problems, so that they sue a bunch of users. This is, I think, the worst technique. They sue a bunch of users and they know that they cannot they cannot adequately defend themselves, and it's cheaper to settle. Those are sorts of things that should be targeted. That's not going to make patent trolls go away. That's not going to make patent assertion entities go away. They're here to stay because of these broader changes in our economy. The last thing I'll say is just there are some issues about patent quality. I think much of what was said on sort of this side of the panel I agree with in terms of patent quality. I was responsible indeed for litigating one of the cases recently, well, in the last 10 years, that tried to increase the standard for getting a patent. In other words, make it harder to get a patent by making the non-obviousness requirement more stringent. I've written a lot about that as an academic. I agree with that, but that's not going to get, and I very much agree with those critiques of the patent system. There are many problems with the patent system. Patent assertion entities will show us those problems because they will be able to assert more patents, but they themselves are not going to be changed, and they themselves are not the problem. I think that they are just showing society that we need to improve our patent system, and hopefully they will help us do that.
Thank you, John. Well, I have a couple of questions, and then I'll throw it open to the audience, and I'm sure the audience will have questions. Let me kind of try to take off, I think, from what Peter was saying, perhaps more than anybody else on the panel, which is focusing on litigation issues, which it seems to me is where we basically are in the public policy debate. Right? The legislative proposals focus on litigation issues. The White House's proposals focus on litigation issues. So I guess let me just throw out kind of two related questions. One is kind of at least one of the motivating factors behind these proposals is that there is an asymmetry in litigation costs as between plaintiffs and defendants. The system has an asymmetry, which is problematic. And so one of the aims of the proposals is to try to at least partially correct that asymmetry. And the kind of the second related question is, can there be, why should there be any objection to reducing litigation costs and making the litigation system more efficient? So, anybody can take that.
I'll start. I hope you
No.
is objecting to that.
No,
We agree.
I didn't.
I don't think you're ever, speaking just to someone who's been in this industry for 30 years, I don't think you're ever going to cure that asymmetry. But you can certainly make litigation more efficient. There's no question. I think I think this is a good last proposal. Matt, correct me if I'm wrong. It calls for a very limited discovery until you get to the marketing phase. I think for the most part that's a reasonable goal. I think you need to be careful about, anybody who's actually practiced patent litigation will tell you that you can't say there should be no discovery until you get, because you need to be able to winnow the issues so you know what is the appropriate issues to raise, what are the appropriate issues to raise it. You don't want to have the judge construing claim elements that actually turn out not to be relevant because with a little discovery, the plaintiff would have learned, oh, the product doesn't work the way I thought it was, let's drop that patent. Or, oh, they've got, this is the relevant prior art, therefore this is going to be the claim issue that we need to interpret. So I think there needs to be some discovery before you get to the market phase. But, and frankly, a lot of the local rules and courts already account for this because they are the ones who, have the most experience, and they also want to be efficient with their time. That's a long-winded way to say I agree.
Yeah, just I am a little more familiar with the Good Life Bill. So there actually is, there is a way of exchanging the documents that Peter was talking about. This set of core documents will be required to be exchanged, and that includes documents sufficient to show how the accused products work. So ideally, at least, the judge is left some discretion for scheduling discovery, but the goal there is just to reduce costs. As far as the other litigation-based proposals, they are, as Tom said, really directed at trying to reduce some of the asymmetries. Now, one of the big asymmetries is an asymmetry of information. So if you've been through patent litigation, you know that a lot of, as a defendant, a lot of time and money is spent trying to get really basic information that you're entitled to. Things like verifying that the ownership of the patent is correct and settled. There are often problems with patent assignments that don't turn up until later in the case when you finally manage to get the assignment documents. Finding out who the ultimate parent company is, because it may be that you're entitled to a license that you got through the parent company. There's a lot of information that you need about what you're accused of. What claims are being asserted against you, which ones. The patent may have 100 claims in it or more. Which ones do you need to worry about? What product specifically is being accused? I've been in cases where it took us months just to find out what we were actually accused of. In one case, it turned out that it was a product that was never built. They had found, through a Google search, they found an old marketing document that had been written for something, and the product had been planned, and then they hired a contractor and then decided not to do it. So we were accused of infringing on a product that didn't exist. But if we had been told in the complaint more clearly what it was we were accused of, we could have avoided months and months of litigation costs. So, obviously, we're not going to, as John said, I don't think we can do away with trolls, but the idea is to change the economic model, because I think that what we've seen, there is real growth in patent troll litigation, or PAE litigation. I'll try and be nice, I don't want to hurt Peter's feelings. The study, actually, that Peter cited, the GAO study. Yeah, I'm sure. I'll try harder. What was I? Oh, the GAO report. So the GAO report, actually, it's funny, the numbers, the data underlying the report that Mike cited and that Peter cited come from the same source. In fact, the people who collected the data are the ones that Mike cited. The GAO was a bit more conservative in who had considered what he called a patent monetization entity. But if you actually look at the data, in fact, from 2007 to 2011, the number of companies that were sued quadrupled. That's right there. I think it's page 18 of the report, but I could be off. But either way, the number quadrupled. So there is, in fact, a large increase in this, and I think it's because the model is so profitable. So the idea is, if we make it less profitable, we'll see at least a reduction in the increase of growth, and maybe we'll even see a reduction in the number of people who choose to do this.
There is one thing that you must realize, that if you decrease the cost of litigation, which everybody's in favor of, you make litigation less costly, and that means that people will usually buy more. Right? So if you make litigation less costly, except for this collective action problem, it means that people who have patents to assert will now think, wait a minute, I wasn't going to assert this patent because litigation is too costly. But now I will assert it because it is less expensive. And that's why I think both sides would like to decrease litigation costs. And I don't think there's anything wrong with decreasing the litigation costs. It's just that don't assume that because we decrease litigation costs that that there will be fewer suits. One would think that by any mechanism you would think that it might vary. By several mechanisms you might think that you get more suits.
Well, you might get more suits.
They'll be less expensive, which is good.
But if you decrease them at the same time that you correct an asymmetry, you may in fact get fewer suits.
If it's
asymmetry may be responsible.
That's right. So if there's an asymmetry, that's right. If you say, well, there's an asymmetry of costs, that's right. It's possible. But if we want to talk about asymmetries, I think the most important asymmetry is the asymmetry between the process that's allowed to the party seeking the patent versus the parties challenging the patent. In every other administrative agency in this town, the party who seeks favorable government action, if they succeed in getting it, the parties who are harmed, meaning their competitors, are always entitled to judicial review of that. That's a generalized statute called the Administrative Procedure Act that guarantees that right. Anybody who's practiced before any other agency knows that's true. That statute on its face applies to the Patent Office. The Federal Circuit in recent case has held that no, there's an implied preclusion, even though the statute doesn't say anything. The parties who are harmed by the PTO's granting of a patent cannot get judicial review of that decision. That's controversial, I think, and should be more controversial than it is, because that's not only an asymmetry, but it's an asymmetry that's out of step with every other administrative agency. It's out of step with the text of the statute, and it's something that should be talked about a little bit more.
So I'd like to make 2 points. One on the data. It's interesting because Professor Moyer said right here that the primary source of data for his event study was RPX. And RPX
patent freedom for the event study.
I apologize, it was a different study that used the Lex Machina data. That said 50%.
RPX for the survey, patent freedom for the event study.
Okay, RPX for the
survey.
Okay, and patent freedom is McCurdy's group, right?
Right.
So, okay. So both RPX and Dan McCurdy, who runs Patent Freedom, also runs an outfit called AST. Both of those entities are in the business of selling essentially patent insurance. Companies that want to sell that product need to create a boogeyman. So, that data I think has to be looked at carefully. In comparison to GAO, they did look at the RPX data, but they also looked at a lot of other studies, including Lex Machina and a number of other sources to come to their conclusions. So that kind of goes to my point of, yes, there's data out there, but there's a lot of misleading data out there. On the administrative point, I am not an admin law scholar, so I couldn't possibly address the point that Professor Duffy was referring to, but I just want to give one anecdote. I was recently on a panel with Judge Lucy Coe, district court judge in Northern District of California, she heard the Samsung Apple case, former litigator in, I forget which firm, maybe? I forget, either way, she's now a district court judge. And halfway through, she practically exploded at the representative from Cisco, the general counsel of Cisco, Mark Chandler, saying, why is it that in every other administrative action I deal with, you deal with an administrative agency and then you're done, and then I get to review it subject to all the, why is it that you get to go back to the patent office 2, 3, 4, 5 times for all these extra bites at the apple to have the administrative process reviewed and drag out and make my life so much more difficult? Because why isn't it ever done with you people? Why can't we just be done with the administrative agency and then you come to my court and I'll rule? You may not like how I rule, but that's how it's done with every other administrative agency in this country. It's an interesting discussion.
I want to say that that's very interesting.
Give me a chance.
Okay, I'm sorry.
Let me quickly comment on what Peter just said. The data that we got from Patent Freedom was simply identifying who the parties were that were asserting the patents. And it's not really very controversial. Other people can use public records to replicate that. So initially, the key thing for that event study was just finding out which patent suits were being asserted by NPEs. People will disagree about who to put into that category, and other people will do studies and will have slightly different definitions. In the end, it's not really going to matter very much. People might be more concerned about the survey. That's a completely different issue where the response is truthful. We can talk about that. I don't want to do that right now, but we can later if people would like to. But the GAO, as Matt was saying a second ago, pointed to the RPX study and said, we're using that to confirm what we got from Lex Machina to make sure that the numbers in Lex Machina look right, and that seemed to be, they seemed to think that RPX was suitable for that purpose. But anyway, what we've done in the event study could be replicated by anyone else. They just have to go out and find the lawsuits and try to replicate our study if they want to. So that's easily done. Back to Tom's question and this discussion of asymmetry. You heard some discussion kind of law and economics litigation. I want to make sure everyone understands what's at stake here. Question number one, will there be more or less litigation? Question number two, when litigation occurs, how many resources are burned up? Question number three, we haven't talked about yet, which is the most important question. What's the bargaining power of people that are negotiating in the shadow of litigation when you change an environment that is favorable to an asserter to make it more balanced? You are going to reduce, in typical cases, the expected settlement payment that will be made. So when you take a small, successful startup company like Research in Motion, or like Microsoft, or like Google, think back, guys, those were all small, successful, high-tech startups. We issue tickets to strangers to take them to court to sue them. And if there are asymmetries created by very low discovery costs on the plaintiff's side, very high discovery costs on the defendant's side, because there's no invulnerability to a counterclaim, that's the attraction of an NPE. That's why the costs that were already present when operating companies were asserting poor quality patents, those costs, the patent tax has been increased. The problem is aggravated. We need to deal with the asymmetry because we want to reduce the magnitude of the patent tax. Patent litigation, that's important to think about, but that's not really the essential problem. The essential problem is the magnitude of this tax. And that's why we want reforms that reduce the bargaining powers of patent asserters, whether they're NPEs or operating companies.
So let me, John, I'm sure you will say what you want to say anyway, but let me just add another question, a related question to all of this. And again, I'd like to get into, obviously the bills are different, but we now are, at a stage in this debate where we're talking about specific types of provisions, like legislative provisions. And I guess my question is the type of legislation that's now being proposed, the types of provisions that are being proposed, will they impede legitimate assertions of patents by anybody, including PAEs? And if so, why? Peter must have an opinion on that.
Well,
At least on some of the provisions.
I'm trying to think on behalf of an industry, what the net result would be. I think that the fee shifting will be a deterrent to some people, will be a deterrent to us.
Well, it may be a deterrent, but obviously it's going to,
We researched the hell out of a case before we bring litigation. So we're confident that won't be an issue for us.
Many people, just as an aside, and John, I'm sure knows about that tonight, many people have been suggesting a loser pays system much more generally in this country for years.
Yes, that's why I'm hesitating. I think that there are some legitimate concerns that it could decrease access to courts by entities that are not as well funded as we are. It's more of a calculated risk on their part. We have the luxury of doing a lot of research ahead of time. We don't, the cases we file, frankly, are big ticket cases, and we have no desire
to bring one of these cases unless we have a strong, and we could be wrong. I mean, can't make no mistake, we're going to be wrong sometime. I think we're always right, but wrong. But we have the luxury of doing our homework. So, you know, if you're asking on behalf of Intellectual Ventures, I'm not sure there will be that much of an effect that you're asking with respect to other PAEs that I'm familiar with.
Well, so I think the question was, will this have an effect on legitimate assertion? And I think the answer is basically no. I could stop there. But it's,
you won't.
I won't. Come on. You give me a mic and I'm going to keep talking. So the reason is that for legitimate assertion, actually, as Peter was saying, you do put quite a bit of work in. And so just looking at the loser pays provision, if you look at the text in the proposal in the Goodlatte bill, there's something similar in the Cornyn bill. The idea is that you are entitled to fees unless the other side's position was substantially justified. So, you know, you're not supposed to be filing a claim unless it's substantially justified by the facts that you know. That's in the federal rules. So certainly, you know, it sounds like, taking Peter at his word, if you put that much work in, even if you're wrong, your positions are not frivolous, they're substantially justified, you just may turn out to be wrong. So there's not that much risk of actually having to pay. The point is to go after those plaintiffs who really don't have a particularly strong case and are hoping to use the asymmetries we've been talking about to improve their bargaining position.
Okay, but let me give you a hypothetical here. So somebody's got a patent that reads on Microsoft Windows, and they come to me and they say, "Will you buy it, Peter?" And I'll look at it and I'll give a price, and they say, "No, that's too low." I think that this reads on the core technology in every product, every copy of Windows that's ever been sold, and I think I'm entitled to a lot more money. You know, no PAE will give them that kind of money, so they then will go to likely a contingency fee law firm. Contingency law firm will look at it and say, "We've got a good case here, Mr. Inventor. You know, we've done our homework. We think it's a good case, but you know, there's a risk out there, which is that a court could disagree with us. If they disagree with us, we're going to have to show that this was substantially justified for us to bring. We're not sure what that standard means. We've done a lot of homework, but if not, you're going to be on the hook for Microsoft legal bills." Now, that's a risk I'm willing to take because I have the resources and I'm confident in my position. But I don't know that your average independent inventor is going to be willing to take that risk.
I think a really instructive setting to look to help answer your question is biotech. Biotech for a long time has been decentralized exactly the way John was talking, right? And who can think of a large patent aggregation firm that operates to make possible transactions between big pharma company and small biomedical startups? I can't think of any. You know what I've heard about making the market work for transactions involving technology? You go to the annual bio meeting and you meet with people. There are people that pull technology, people that want to use the technology, and because the patent system is working pretty effectively in that sector, we don't need intermediary market makers who really don't serve much of a purpose because the underlying asset is so incredibly diverse, no one ever really gains the expertise to play a sensible intermediary role. We hardly see any NPE assertions. Only 1% of the NPE assertions in our data set are associated with chemicals. Only 1% are associated with medicine and pharma. Almost no NPE activity there. We have disaggregation. We have firms operating in an environment where they have strong patents that protect their underlying technology, but most critically, there are buyers that want not only the patent rights, but they want the technology. When we move into the sphere that Cisco is operating in, we generally get companies that are having to buy patent rights, but they don't need and don't want the technology, and in fact, the sellers often have no technology to offer. They have a patent that has language that might be read very broadly to cover something the inventor associated with that patent never dreamed of and could not possibly enable. So the disconnect between technology transfer and patent rights is a very big problem, one that we don't see in a decentralized industry where patent rights are important and where they're very successfully enforced. They have been before this litigation, they will be after this litigation, because they've got good, strong patents. And they've got VCs that are willing to fund patent enforcement if necessary.
That's because, I have to respond to this, that's because Cisco and the other tech companies respond to a law that does not apply to the biotech companies. It's a law more powerful than anything the Supreme Court has ever dealt with. It's called Moore's Law. That requires, that calls for integration in every electronic device of more and more functionality. That is functionality Cisco did not invent. Cisco will be the first to admit it. Cisco will admit that they did not invent everything that's in their products, and they need access to it. They need an efficient way to get access to it. Moore's Law trumps patent law.
Well, I just want to address.
I'd like to get to
I would like to address Peter's, because he had this example that.
I want to get to the audit section.
This won't take long. So, we have this independent inventor that Peter's talking about, who's unable to get his litigation funded with his patent that supposedly reads on Microsoft Windows. There's one thing to remember, which is what Mike was talking about earlier, notice failure. I can guarantee you that any patent that supposedly reads on Microsoft Windows is not crystal clear. This is not a chemical compound that you can line up and match up to something that exists. It is always going to be subjective. There is absolutely no way to be sure. You can think it's very likely to win, but it's not crystal clear. We're not talking about someone taking my car, and I can say, well, that's my car. I know because the VIN number is the same as the one on my title, right? I can identify that as my car. That's not possible here. So there's a lot of subjectivity. The fact that the inventor may personally believe that Microsoft owes him a ton of money doesn't mean that it actually does. It's only after we go through all this determination. So the thing about this is that this is not the clear-cut, hey, you're trespassing on my land case. This is, we have a potentially ambiguous dispute, which after the court resolves it, I might win.
Okay, let me open it up to the audience, and if there aren't any questions, we can continue with this. But any questions? And if you could identify yourself and your organization, if you have.
I'm Aaron Stanley with the Financial Times. Just going back to the GAO study, one of the interesting things I noticed from the study was that while they point out that the amount of defendants tried in these NPE cases has quadrupled, it shows that the share of NPE lawsuits has basically remained the same, around 20% over the past, since 2007, I believe, which it seems to indicate that it's the number of defendants, being tried in these cases has grown. It's the same amount of cases, but there's more defendants are involved. I'm just wondering if there's been any inclusion in the legislation in Goodlatte or wherever else to perhaps minimize the amount of defendants that can be sued at one time in these cases, and what the potential effects or effectiveness of that might be.
That provision was in the original American Invents Act. So you can't aggregate defendants into multiple cases unless there's some close relation between the cases. Just the fact that you're accusing them of infringing the same patent is not enough.
Which actually accounts for a lot of the explosion, not the entirety, but a lot of the increase in the number of litigation, because what used to be one case against 4 defendants is now 4 cases. That leads to a 400% increase in litigation.
Right, and that's why it's important to count the number of defendants.
Also, take a look at Robin Feldman's latest work. She, working with people at Lex Machina, provided the data to the GAO, and her recent conclusion, post the GAO report, is that the statement you made is not correct, is that both number of suits and number of defendants has gone up post AIA.
Thank you. David Hatch with Managing IP. Mr. Decken, what's your overall assessment of the Goodlatte bill that was just introduced a few days ago? Does it strike the right balance, and what impact would it have on your company?
Well, as you just said, it was introduced, I think, less than 48 hours ago, so haven't had a chance to do a detailed analysis, so let me give that caveat. By and large, we are in agreement with the spirit of almost everything that's in there. I think that the devil's in the details. For example, one of the things we call for, and I mentioned this before, is heightened pleading standards. And he said, you know, it makes it clear that, I think in fact it says, please, you know, get rid of that Form 8, I think it is in the FRC, is that right, Form 8? In the federal civil procedure.
18.
Form 18, yeah. I said, it explicitly says get rid of that, because that is not the standard for patent infringement. We're fine with heightened pleading standards. We think that's by and large a good thing, giving more notice of what the rights are that are being claimed and what are the accused products. Again, I think that there's you know, the devil's in the details as to how you implement that, and we've working with Representative Goodlatte's office. We continue to work with his office, and I think that's true for almost everything in there. We're generally in agreement with the direction of the bill. We just would like to work with them on the implementation.
Could I just quickly follow up? Are there any particular provisions that you have? Are there any particular provisions that you have concerns about at this juncture?
We think that there are many ways. They have fee shifting in there, which, as I've said several times, we're okay with. They also want to ensure that there is money available to pay in the event that there is fee shifting that occurs at the end of the case. And we think that there are better ways to achieve that. There are a number of ways to achieve that. We would like to work with them on what's the best way to achieve that.
Would you comment on the covered business method expansion?
I'll be honest, I'm not as familiar with what has come out of that. I know what Senator Schumer had proposed, and I thought that had gone a little bit too far, but I don't believe that Representative Goodlatte goes as far as Senator Schumer did, and that has to fall into the 48-hour exception of I just haven't had a chance to analyze it, I'm sorry.
Wait for the microphone.
Milton Mehta from the Axel Lines.
There you go.
Milton Mehta from the Axel Lines. So I had a quick question for you. So there's a lot of conversation about the CDM program, and I'm just curious, what are the downsides of putting a legitimate patent through the CDM review process? If the patent's questioned and you want to put it through the process, I'm just curious for a company, what's the downside?
Is that a question to me?
Sure.
The downside is simply that you're introducing even more delay and even more inefficiency into a program. There already are 5 ways to challenge a patent. Matt identified a few. I think he left out re-examination, which because that was not introduced by AIA, that was already there. You have inter-parties re-examination, which can occur within 2 years. No, wait, I'm sorry, I think reissue. You have reissue, which can be within 2 years, one way to re-examine a patent. You have re-examination, which can occur at any time during the. There are many, many ways to attack a patent. Adding even one more kind of gets me to Judge Coe's frustration of, my God, how many times do you want to have a bite at the apple in the patent office? Let's get this in the courts, let's get it over with.
It is true that just in administrative law, the number and complexity of administrative mechanisms to challenge a patent, then coupled with litigation, which will also decide validity, that has multiplied tremendously since the AIA. And I think that that's just a function of compromise, right? There's a compromise and you get this plethora of various things, each of which are tweaked in a various way, but there's no sort of central, quick, expedient way to engage in judicial review of the administrative action, which is the way it works in other agencies. Instead, we have a diversity of ways which can conflict. There can be several going on at the same time. One thing that you can note in the statute itself, it talks about, there are different provisions for the director to decide how to handle multiple proceedings. There's actually 2 provisions that deal with that. They're not even consistent, but it sort of gives you some sense that there is tremendous complexity, and that tremendous legal complexity raises costs.
Well, maybe Matt can answer this, because I'm just kind of confused about this, that the review procedures in the AIA, they only apply to patents issued since the AIA?
No, they apply to other patents as well.
Some do.
Some do. Yeah, the post-grant review only applies to patents that were filed after, was it March?
The ones that are the first to file.
Yeah, the first to file patents. But
The inter partes review, which you had on your slides,
That's right.
that has replaced what was used to be called
Inter partes reexamination.
reexamination. That has.
And there is still something called ex parte reexamination, which is, you just requested, that's what Peter was talking about. But my point actually was the same, it's still just as limited in what you can ask for review. But to get to your point, that actually, in the first year, the delay has been about, or the time it takes from filing to getting a decision on your petition as to whether or not to review has been an average of about 5 months. So we're not talking about a ton of delay here. Courts are also, although they are tending to stay the litigation, they haven't done it in every case. So, we're already seeing that there's not this huge stack up of delays. It's actually giving the Patent Office a chance to review. And remember that for a covered business method review, these are administrative patent judges doing it, not examiners. So these are more experienced, more knowledgeable people with a strong legal background. So, we're not just talking about patent examiners taking another look. These are actually administrative judges.
I think there's somebody waiting there.
Hi, Dustin Volz with National Journal. Is anyone on the panel explicitly against Chairman Goodlatte's bill? And if you're in support of it, do you think it's the best legislative item that's been introduced this term? There are about a half dozen, I think, that have actually been put out there. And if it is one that you're supporting, is there anything that you would want to push for within the legislation, such as the business review method, anything that you would add to it to strengthen it? Thank you.
CCIA generally supports the bill. I don't know about, that's like a Stephen Colbert question, is this great legislation or the greatest legislation? It's a really good bill. We've said openly that we would prefer to see the CBM program expanded further, more along the lines of what Senator Schumer introduced. But this is still overall a really good bill. There are one or two things that I know people are concerned about. Not to get too far into the weeds, but there's one provision we haven't talked about which protects end users. So it allows companies to intervene in a case to protect their customers who've been sued. And I know that they're actually working with Senator Leahy's office. So they're eventually supposed to be taking whatever Senator Leahy comes up with, and that's what's going to be in the bill, which should, I think, allay some fears that some people have had about that provision.
Alden?
Alden Abbott, Blackberry. Anybody have any comments on the various Section 337 legislative proposals regarding definition of an industry and the importation proposed by some of an eBay standard into 337 proceedings?
Is there a proposal to change the definition of a domestic industry? I haven't seen an actual one. As far as the eBay standard, we think that's actually makes some sense. It would make it more consistent with what's done in district courts as far as injunctions go.
So he's staring at me. I think he wants me to answer as well. Do I have that glare right? And have I correctly called that a glare? I think that was. Okay. This is a nuanced discussion because I understand the superficial appeal of what you're saying, but let me tell you about our one experience. We've had one 337 case. If you're not familiar with 337, that's when the ITC, acting under 19 U.S.C. Section 1337, by the way. There you go. This is a law school exam, apparently.
It's the International Trade Commission.
International Trade Commission, thank you, has the ability to stop the importation of products that are produced by unfair trade practices, which includes patent infringement. 337 actually says intellectual property, either patent or trademark. And there is a debate as to whether a licensing entity, you have to show that there's a domestic industry attached to the patent, and there's a question as to whether a licensing entity constitutes domestic industry associated with the patent. So we have brought one case, it was in the memory field, and in that field, we had licensed the major U.S. memory manufacturer, Micron, to our patents. Micron was paying, I can't tell you, it's under NDA, but it was a fair amount. What we thought was a fair amount for our memory portfolio. Our memory portfolio is several thousand patents. And there were companies that were importing competing products that were not paying their fair share, their fair license fees. To us, that's an unfair practice. Micron thought that was an unfair practice. I think that there could be no question we were protecting a domestic industry. So I can get my words confused in that instance. We were protecting a domestic industry. That is a classic proper use of Section 337. So I have no apologies for our use of 337, and I think had we litigated, we'd settled that case, but had we litigated and obtained an exclusion order, I would have no problem standing up and saying that was the proper use of 337.
Okay. Somebody back there.
Thank you. Alan Marco from the U.S. Patent and Trademark Office. First of all, I want to thank the panel and also the diversity of the panel. And considering the diversity, it's interesting that there are some common elements coming out. And my question is about information. And a couple of the panelists mentioned this. I think it's interesting that Professor Duffy used the example of a used car market, because that's the classic example used by Akerlof, Nobel Prize winning economist, in talking about asymmetric information and looking at areas where, because of asymmetric information, the market may break down. So if we're thinking about, and the White House has tasked the Patent and Trademark Office to, in fact, require more information from applicants. So my question is for the panel, if there's a single piece of information that would be helpful in making the market more efficient and more complete, what would it be? We've talked about ownership information, we're an ultimate parent company. Is there something else? Is that the most important piece of information that could be obtained, would be useful, or is there something else as well?
Well, I mean, speaking in terms of what the Patent Office could gather, actually I think the most important information is the meaning of the words in the claims as intended by the applicant. So there have been, the President proposed something called typing functional claiming, which is an effort to really crack down on some of what Mike was talking about, the tendency to claim these software-related inventions very broadly using functional claims. So I know that there's been a new training program in place for examiners. They're also looking at a pilot program to add glossaries to applications. So again, it's not intended to limit what an inventor is entitled to, but just to make sure that when the patent issues, it's as clear as possible what that covers. So that's really to address the notice failure problem that we heard about earlier.
I agree completely with what Matt just said, and I'd like to push the PTO further to leave a more transparent prosecution history. Prosecution history generated by examiners who are more active in asking questions or making observations about what claim language means. So that prosecution history is potentially available to help increase our understanding of what a patent means, but we don't do a very good job of generating that history or of disseminating that history. And so a change in the orientation of what examiners think is important. It's of course important to look at 102 and 103 issues, but I don't think the agency in many technologies appreciates how important it is to generate information about what the claims mean.
Here's another instance where you're going to find violent agreement on the panel, because I generally agree with what my colleagues up here are saying about notice being an issue, and anything we can do to improve that would be great. But I just want to add a note of caution and tempered enthusiasm, because let's keep in mind that we are asking, I mean, I did a lot of prosecution in my day, and I've done a lot of litigation of patents, and you're asking people to describe in words something that by definition has never existed before. And at the end of the day, it's going to be hard to get that in perfectly clear terms. So listen, I'm all for improved clarity. Don't get me wrong about that. And anything we can do, I think the glossary is a great idea if you can get an agreement on it. I think that anything we can do to improve the notice functionality would be great. But let's temper expectations as to what can actually be achieved.
Let me since we're approaching the end, let me ask a wrap-up question and see if we can also get file an agreement on that.
I like that phrase.
I like that phrase. when we're looking at the types of litigation reform proposals, the Goodlatte bill and other bills, that general type of approach and other bills that are under consideration, would any of them do anything to fundamentally change the patent system, particularly as it applies to software?
Well, don't forget, this is where what I said before, those bills are aimed at litigation, not patent.
Right.
So you said the patent system.
Well,
The bill
litigation
will change the
concerning
patent,
the
the
patent
patent,
system.
oh, the ecosystem, okay, so, yes, it would change the patent
I
litigation
mean,
system.
Patent litigation system,
Patent
not the
litigation.
patent system.
The patent ecosystem, but the patent system itself was built to address.
I agree on that, that it changes
Well, that's
patent
my-
litigation.
that's
And,
my
and many of the critiques about patent quality, and about what should be patentable and the standard of patentability are left unaddressed by this bill. And really, we're left unaddressed largely by the AIA too. And it is true that the fuzzy boundaries or notice problem that Professor Moyer identified, I must say, you have to understand that in most industries, that's always been the case. If society has a patent system, when you're trying to put down in words the rights to intangible, invisible, conceptual ideas at a fairly general level, if you're going to have such a property rights system, you're going to have difficulty running that system. You know, only a very sophisticated society can have such a system of property rights. And even then, it's very difficult to have such a system. So it's better to hope for the future, but you just shouldn't say, well, we should only have a property rights system if we can sort of see it, touch it, and feel it like land and put a line right down there. Certainly a very primitive society would say that, but I think a 21st century society would never say that.
Well, I thought we were just going down the road. Okay. So I think I'm going to give a lawyer's answer, which is it depends. It kind of depends on what you mean by the patent system. If we're talking about the rights of patent owners in particular, or what's patentable and what's not patentable, that's not affected by any of the bills, as you've heard. That's actually important because one of the criticisms that's been levied at the expansion of the covered business method is that it will somehow destroy innovation and harm people's patent portfolios. But as you just heard, the standard for what's patentable doesn't change at all. But if you think of the patent system a little more broadly, as including those companies and people who are innovating and doing things that may or may not infringe on people's patent rights, and I think it's important to keep those people in mind, then it does change that, because although people with legitimate strong patents are not going to be affected, the people on the margins with the weaker patents or the shakier patents who are leveraging these asymmetries that we've been talking about all morning to make money will have a much harder time of it. So I think in that sense, it should change the patent system for the better and help us get more innovation, more legitimate innovation out of it, which is what we want, and reduce the drain, this innovation tax that Mike mentioned. So overall, I think it will change, and for the better. I'm not claiming it's going to fix everything, but it certainly should be a big improvement.
The AIA, just a few years ago, we had this reform. I think not really a very significant reform. It hasn't done very much. Some people say, let's pause, give it a chance to work. There's not much there. The critical reform associated with the original AIA was reforming remedies. And we got the eBay case, and we got some cases from the Federal Circuit related to damages. What was really valuable was accomplished by the courts. That might happen again with the Supreme Court taking a look at fee shifting. I'd be happy to see Congress push that forward. I think the Goodlatte bill is more valuable than the AIA was. I think it is still a fairly modest reform. The comments that Peter and John made about the difficulty of getting these property rights right, I agree with them. It will be hard. It is a struggle. John expressed that, I think, just the right way. Sometimes it's so difficult to find the words to create a useful property right that some ideas just should not be propertized. John strongly disagrees with me, but I look back to...
That's not true.
I know, well, I know you believe, well, listen to the rest of what I have to say. Bilski, 5-4 with one judge waffling in between, we almost had a categorical exclusion of business methods. We should. We should have categorically excluded business methods because they are too hard to propertize through the patent system. And expanding covered business methods to all business methods, not just finance-related business methods, is a very sensible thing to do. Because no matter how hard the PTO and the courts work to inject greater clarity, we're just not going to do a very good job. And on top of that, there are tons of different methods for appropriating value from new business methods. The patent system has never been very important as an incentive to encourage that sort of activity, and we should not fear at all a decline in the value of patents held by patent owners that relate to business methods. They cause a great deal of mischief. They disrupt other people's innovative activities. They provide little benefit that I can't argue strongly enough for a very aggressive expansion of our treatment of covered business methods.
Okay, do I get a minute? I'll just say that as society advances, it not only creates better technology in fields that we already have technology, but it also makes other fields that previously were not technological into technology. I had an article a couple years ago in Stanford Law Review, I know you're familiar with this, that looked at what engineering schools have done over the last quarter century with financial engineering. And that went from some mysterious pseudoscience into something where almost every major engineering school in the top 20, if you use some various ranking systems, has degrees in something called financial engineering. Most of that activity occurred before the courts said business methods were patentable. It predates that. So if you say, what's the driver of business method patents? It's not our legal system. It's not some lawyers coming up and saying, gee, we should really think about this area of economics as like engineering and as like technology. That occurred at least a decade prior to the crucial decisions with indeed an issue of a major journal devoted to financial engineering. And I think if people begin to think of themselves like engineers, they begin to seek the sort of property rights that engineers have traditionally sought. And that's what we should expect, and we should welcome that. We shouldn't think that these things are so abstract we can't do a better job. Technology can do a better job. It may take a while, but it can do a better job, and we will do a better job. We are a sophisticated society, and we're getting more sophisticated. The argument that we just can't do it is not plausible.
One sentence. If you ask software engineers, should we have patents on software? It's not clear, but I think most of them you ask would say no.
Okay, well, this is obviously a subject that is not going away, and I would like to thank this panel for a very, very interesting discussion. I really appreciate it. So.